I'm Susan Swain, host of C-SPAN's Q&A, where we spend an hour with nonfiction writers and historians who add context to today's news. 20 years ago, the presidential election was decided by a 5-4 vote of the Supreme Court. This week, our guest is Los Angeles Times Supreme Court reporter David Savage, who's been covering the court since 1986. He talks about Bush v. Gore, why it happened, and its implications for election 2020. David Savage, it's the 20th anniversary of Bush v. Gore, and here we are in the midst of sorting through another close election. We asked you, because you've been covering this Supreme Court since 1986 for the Los Angeles Times, to come back and look back in time with us at that 2000 election, what we were going through then as comparison to what is happening now, and also some of the lessons that were learned. So let's start with the court itself in 2000. The Rehnquist Court, 9 members, and 7 of them had been appointed by Republican presidents. But how did they align ideologically?
Well, it was pretty much of a sort of a 5-4 conservative court. Rehnquist was the real leader of that court. Justice Scalia was a prominent figure. It sort of leaned right. There were several moderate Republicans. We don't see a lot of that. John Stevens, David Souter, and Ruth Ginsburg and Stephen Breyer were the sort of 4 on the left. So it sort of leaned conservative, but it was also an interesting era. You know, the court's never 100% predictable, and I always found even then that Justice Kennedy and Justice O'Connor were sort of middle of the road conservatives, and you could not predict them in all sorts of cases.
Would you say a bit more about the Chief Justice William Rehnquist and his approach to leading the court?
Well, he had been on the court for a lot of years before he became the Chief Justice. He was a person of very strong and very clear views. I got to know Rehnquist a bit. I go to lunch with him every year, and I always found him the most interesting person. He could talk about all sorts of subjects. He was sort of an ideal lunch guest, because if he wanted to talk about sports or politics or the weather or whatever, and he was a person who liked to get out of the court and talk to people. I always found him. And he also was a very good leader. The justices really appreciated that Rehnquist was very straightforward and clear. He respected their views. He knew people had different views, but he was a very good leader for the court. And he also had a sort of, he really was a sort of ideological leader. He had strong views about the separate states having authority and all that the federal courts wouldn't be overbearing. And over a lot of years, he sort of moved the court in his direction. So
he was states' rights oriented in his philosophy. Among the Republican appointees, in addition to Antonin Scalia and Clarence Thomas, were there any other of the ideology we're so familiar with now, textualists and originalists?
No. Justice O'Connor and Justice Kennedy were, as I say, sort of moderate conservatives, but originalism was pretty much the province of Justice Scalia and Justice Thomas. I remember Justice O'Connor and Kennedy basically thought, that we've had 200 years of precedent on a lot of questions, things like equal protection of the law or due process of law were not defined in 1787, and they didn't have a lot of regard for trying to figure out what the understanding was of all those questions. So no, it was not a court that was dominated by notions of originalism then the way it is now.
These questions become important in understanding the decisions the court ended up making. So we'll come back to them as the events play out. So just as this week, the morning after the election in 2000, neither candidate, Al Gore nor George W. Bush, had achieved 270 electoral college votes. For people who have forgotten the history, President Bush, then Governor Bush, won 29 states, 246 electoral votes. Vice President Al Gore, 18 states plus D.C. with 260. And the focus then turned to Florida, which at the time had 25, now 29 electoral college votes. So the teams, can we assume that they had established legal strategies long before Election Day?
No. No, I think both sides were sort of left scrambling because you can never, Susan, when I think back about it, then it was obvious, I suppose, even then, that the single biggest fact was that George Bush was ahead by a couple hundred votes on election night and the next day after all the ballots had gone through the counting machines. So from the very beginning, James Baker, leading the team for Bush, said, Governor Bush has won the vote. It's all over with. He won. Al Gore's team was then left with saying, okay, what do we do? We're only something like 500 votes behind. There were nearly 6 million ballots cast. We need to go back and see if there were votes that were less. The margin is so close. So I don't think they had any great legal strategy prior to Election Day. But after Election Day, both sides had a clear strategy. The Republican strategy was, it's all over. It's time to stop counting. Governor Bush has won. Gore's strategy was, we need to go back, take another look at all the votes, do some recounts. This is very close. We should keep counting. We should not quit.
And along the way, where there's comparisons to today, they'd be helpful. Today, as we understand from reading, both campaigns have had legal strategies in place for quite a while. Is that your understanding as well? Yes.
I mean, they knew there's a possibility of litigation. Everybody's sort of on notice now, particularly since Bush versus Gore. So yes, both sides are on notice of and preparing themselves on state laws, for example, because a lot of this turns on the technicalities of state law. And if you're a Washington lawyer or whatever, you don't know that. So you need to get people in all the states, get them very much up to speed. But then your strategy again becomes sort of like, where's your candidate? Is he ahead or behind? And that determines a lot of the legal strategy from then on out.
Two other notes about the 2000 legal teams. First of all, as you mentioned, the Bush team was led by former Secretary of State James Baker, and Al Gore selected former Secretary of State Warren Christopher to be the head of his legal team. How important was it to, I think, public confidence in the process to have two people of this stature at the head of the legal teams?
Well, both of them, as you say, were sort of impressive people, sort of wise men of their time and their party. Very different approach, very different strategy. James Baker was very much standing before the cameras, being very public and saying, as I said, Governor Bush has won. It's time for this to end. Warren Christopher was much more of a reserved sort of lawyer's lawyer, but not one to spend a lot of time before the cameras, and was a very much more reserved figure. And to some degree, it affected the strategy that Bush's team seemed much more aggressive and sort of running a sort of a public campaign to say, hey, our candidate won. It's time for this to end. That was their consistent message for 6 weeks, and I think it had some effect.
There were hundreds of lawyers involved in both sides' legal teams, but three names of note, of interest pop out, and that is Roberts, Kavanaugh, and Barrett. Young-ish lawyers at that particular time. Are they, other than a footnote to the story, an important thing to note at this point?
Well, they are a footnote for the reason that you know and I know. But I don't really think they had very big roles at that time. It was the kind of case where both sides had sort of the army of young lawyers on the Republican side or the Democratic side. They basically said, rush to Florida and get involved. I was, in the news business. We all knew it. A lot of reporters and journalists said, rush a lot of people to Florida. And so there were a lot of young lawyers who went to Florida, and immediately went to help out. But I don't think John Roberts or certainly Amy Barrett and Brett Kavanaugh had enormous roles. They were people there to help out and chip in, but they were not sort of the key figures leading the legal fight. So
the days between November 8th, the day after the election, and the first appeal to the Supreme Court were just full of legal arguments at both the local and state level. And the first involvement of the Supreme Court happened on November 22nd, a couple weeks later. What, if you had to summarize anything of note between all of the legal wrangling that happened during those first couple weeks before it got to the court, is there anything that stands out?
Well, I'll tell you what I remember, which was that I started reading a lot of Florida Supreme Court opinions at the time, and I realized right away that the Florida courts were very much of the view of the sort of count all the votes. They had a lot of election problems in Florida and in Miami and various races, and they had a sort of philosophy and an approach to the election law to say it's important to get the result right, to count all the ballots. There had been disputed elections in Miami. I even think they even ordered some new elections. So they were very, as a court, very open to the argument of saying, hey, we need to, this is a very close election. We need to make sure all the votes were counted, fairly, that there was no fraud. And so they were, as a court, very open to the argument that Gore's team was making, which was, this is a razor-thin margin, and we should not rush to end this. We should go back, at least be willing to look at recounting votes. The main legal dispute early on was there was a provision in the Florida law that said if there's an error in the vote tabulation that could have determined the outcome, that could be grounds for doing recounts or reopening the election. Now, what does the phrase error in the vote tabulation means? Well, from the Republicans' point of view, and I remember Chief Justice Rehnquist had this very strong view, that was about, suppose the computers had been programmed in some wrong way, and in your county, a couple precincts were left out. And they turn in the votes and they say, hey, wait a minute, we made an error in the vote tabulation. The votes from so-and-so didn't get counted. So we're going to correct that error, go back and recertify and change our numbers. Or there was a power outage on election day and there was some error that, made some big difference. And so you'd fix it. But Al Gore's team took the view that the punch card ballots failed to count a certain number of votes just because they weren't punched clearly through. And it was sometimes 0.5%, even 1%. They wouldn't be counted. They said, see, look, that's an error in the vote tabulation that could determine the outcome here. And so we should go back and re-examine hand by hand those ballots. And so for the first week or two, the really big issue that sort of moved its way through the Florida courts and then up to the Supreme Court was, what does the phrase error in vote tabulation means, and does it authorize the counting or recounting all these paper ballots or not? The Republican view was no, there's no grounds for continuing this recount. The Gore team, the Democratic view was, yes, it's really close. We should continue the recounting these paper ballots.
And as you're describing that, I'm sure people are remembering the images of hanging chads and dimpled chads and magnifying glasses trying to discern the intent of the voters as those weeks moved on. On November 24th of 2000, SCOTUS, the Supreme Court, announced that it would hear arguments. So was this decision that first time that they would get involved a surprise to court watchers?
It was a surprise to many people, many lawyers around the country. It wasn't a surprise to me and a few of my friends at the court. I remember those weeks in early November talking with some of the people around the court building and who were talking to the justices upstairs and basically said they're watching this very closely. And if this recount continues, they are going to be very willing to jump in. And I remember lawyers around the country saying, oh, there's no way the U.S. Supreme Court would get involved in that. And I thought, that's not correct, that there are 5 of them that sort of took the Republican view that Governor Bush had won the count and there was no need for this weeks of going through these paper ballots. And when it was Ted Olson appealed it to the Supreme Court, they moved very quickly to take up the case, and they were going to reconsider basically that question that I said, which was, the error in the vote tabulation, did that really justify the Florida Supreme Court ordering all these recounts? Rehnquist and Scalia were very skeptical of that, and so a lot of people were surprised. They jumped in, but there's one technicality, Susan, that this was still in the phase, something like the certification phase, where they were tabulating the votes within Florida. Everybody thought that was going to be, that Supreme Court case was going to decide everything, and as you know, it really didn't. It was just sort of a preliminary first stage ruling that didn't actually finally resolve the matter.
The case was named Bush versus Palm Beach County Canvassing Authority. December 1st of 2000, the Supreme Court heard oral arguments for 90 minutes. What do you remember about the atmospherics of that day, both inside and outside the court?
Well, there was an enormous focus on, about once a decade or whatever, there's some case, it seems like, like the healthcare case was a couple of years ago. It seems like the whole country is paying attention for at least 1 hour because it sure looked like the court was going to either, weigh in and shut down this voting, in which case Governor Bush would win. That everybody thought there's a good chance, this is the Supreme Court, that they are going to decide the election in this case. So there was an enormous amount of focus. It was it was not a very interesting or it was not a great compelling legal story, because you're sort of falling all over but what does the phrase error in vote tabulation means, and who's to decide that? Is the state court to decide that, or can the federal judges step in and say, wait a minute, that's not what state election law is? And you alluded to this earlier, even though Rehnquist and Scalia were sort of states' rights people, they were suggesting that the federal judges, the U.S. Supreme Court, should step in and overrule the state Florida judges on the meaning of Florida law. And that seemed to a lot of people like, where did that come from? That seemed a little bit aggressive, but that's where they were.
So the lawyer arguing for Governor Bush, you mentioned him, Theodore Ted Olson. Tell our viewers about Ted Olson's background and experience that he brought to arguing this case.
Well, he's a great guy, a great lawyer. He had been, he'd come to Washington with the Reagan administration from Southern California in the early 1980s and worked in the Reagan Justice Department for a few years. Ted is a very, I don't know anybody who doesn't like Ted Olson. He's a very outgoing, very likable person, a person who knew all the justices. He's a very good advocate. He's got a sort of clear view and sort of presses ahead. And he was also the guy who, played the main role of getting these cases before the Supreme Court. I think his instinct early on was quite correct, which was to say, hey, we may not do too well in the Florida Supreme Court. They have this view that I'd mentioned earlier of let's count all the votes and keep counting. He thought we may need to go to the U.S. Supreme Court if this keeps on. And so he was the guy who kept pressing these issues into the before the U.S. Supreme Court. So he was the right lawyer for the right case.
Al Gore's legal representation before the court was done by Lawrence Tribe. Who is he?
Famous Harvard law professor, one of the sort of best known and highly regarded sort of liberal law professors of his era. Had written great constitutional law textbooks. I remember him early on as an advocate in the Supreme Court, and he had some very good arguments and some not so good arguments. The good thing about Larry Tribe was he was really so smart and so learned on constitutional law that there were a certain amount of cases where the justices would just sit back and listen to him, which they don't do too often. On the other hand, he was a fairly liberal law professor, and he was not necessarily going to have a lot of sway with the conservative justices. And so he was, in many cases, he'd run into a real clash with Rehnquist and Scalia and the conservative members of the court.
Now, the court, as I hope most C-SPAN listeners and viewers know, does not allow video of its proceedings, but even at the time they were audio taping their oral arguments, and we have a clip of both Ted Olson and Lawrence Tribe. It's about a minute long, making their arguments before the 2000 Rehnquist court on Bush versus Palm Beach County Canvassing Authority. Let's listen, and we'll have you come back and talk about the arguments they made.
2 weeks after the November 7 presidential election, the Florida Supreme Court overturned and materially rewrote portions of the carefully formulated set of laws enacted by Florida's legislature to govern the conduct of that election and the determination of controversies with respect to who prevailed on November 7th.
Although it is part of the popular culture to talk about how unfair it is to change the rules of the game, I think that misses the point when the game is over, and when it's over in a kind of photo finish that leaves people unsure who won. And then the question is, how do you develop greater certainty? And a rather common technique is a recount, sometimes a manual recount, sometimes taking more time.
So that's a bit of the 90-minute argument before the court. What was the central part of the argument on both sides?
Well, you see, Ted Olson was basically making the argument that the Florida Supreme Court has botched Florida law, that rather than sticking with the law as it was on Election Day, they've changed it. Now, of course, their view was we're interpreting Florida law. We're not throwing it out. But Ted Olson was making the argument that the Florida law basically called for certifying the results within a week or so. As I say, unless there's some sort of computer glitch that messed up the count, you basically certified the results. And he thought they should certify the results and say Governor Bush won, but instead the Florida Supreme Court allowed this counting to be. So as I say, he was making the argument that the Florida Supreme Court got Florida law wrong, and the Supreme Court, U.S. Supreme Court, should step in and change it. And Larry Tribe, of course, has to make the argument is, look, it's a very close election, and the Florida judges correctly want to make sure that all the legal votes were counted, and that we should make sure we count all the votes before we decide who won the election.
3 days later, the court returned a per curiam opinion. What does that mean?
It basically just means it's an opinion of the court that wasn't signed. And I think what you may know some of this detail more than me, Susan, but I think what happened was in a day or so after that, the result was certified in Florida and Governor Bush won. And so in a sense, the Supreme Court didn't need to resolve the issue that they thought they were going to have to resolve. And so they basically wrote an opinion for the court that said Rehnquist's view of this, which was the Constitution from the beginning said that the electors shall be chosen by the manner set by the legislatures of the states. This was the view in 1787, that they were going to allow the legislatures to pick the electors. Rehnquist's view was that the Florida legislature had set the law, and that the Florida Supreme Court really had no basis for changing that law. Normally, state courts determine their own state law, but Rehnquist kept saying federal elections are different. And so he sort of laid that out in a few paragraphs, a few pages, and said, but we're a little bit unclear what the basis of the Florida. So they found a way to write an opinion, make the case go away, because at that time, over just a couple days, they realized they didn't need to resolve it because the certification had ended and Governor Bush at that point had won.
Except it didn't end it. And events move very quickly over the next couple of days, so much so that I asked our producer, Nick Raval, to put it on a timeline so we could go through it pretty quickly. December 6th of 2000, the GOP-led Florida legislature announced that it would convene for the purpose of choosing new electors, a process that is allowed under the Constitution. On December 7th, the Gore legal team makes arguments in the Florida Supreme Court. A lot happened on December 8th of that year. The Florida Supreme Court ordered manual recounts in a 4-3 decision. At the same time, the Bush team seeks a recount injunction from the Supreme Court. And then the Florida legislature starts its meeting process to choose new electors. One day later, December 9th, the Supreme Court stepped in to halt the manual recounts and set a date for a hearing. 2 days later, December 11th, the arguments were heard in Bush v. Gore. And then 1 day later, the Supreme Court announced its decision, which ended the election in a 5-4 decision. We're going to talk about some of the important parts of that step for our storyline today. But why, first of all, why was speed of such essence? Why did events have to move so quickly?
Well, two things. After the case was back in Florida, there is a provision of Florida law that says after the result's been certified, the losing candidate contests the result. And so that's why Gore was back before the Florida Supreme Court saying, we're contesting the result. There are thousands of these punch card ballots. Some of them that didn't register vote, they should be counted. So he was contesting that. The time issue was there is a provision in the federal law that says there's sort of a period where if the state gets its electors settled and decided by, and I believe it was December 12th that year, then they're not subject to any further challenge when they go to Congress. So there's a lot of debate about this, but basically the view was December 12th was the day the state needed to resolve this. So there was, as you say, sort of a real time pressure. The Florida Supreme Court on that Friday handed down this 4-3 decision. I think they said there are something like 40,000 of these ballots around the state, that is punch card ballots, went through the machine, didn't register a vote. They should all be counted. And I think their view was they could be counted Friday, Saturday, Sunday, and Monday, and the count would be completed by the date early next week. I think it was always the case on the Bush team side was they were very worried that if the count proceeded, that Gore could go ahead and then that would change everything. If Gore were suddenly ahead in the vote, then they're in a bad shape because then they'd have to be saying, wait a minute, keep counting. So they did not want that count to continue, and that was part of their driving force. When the Florida Supreme Court decided that on a Friday, Ted Olson was ready on Friday night to file an emergency appeal with the Supreme Court, the U.S. Supreme Court, and say, issue an order, stop the count.
When an injunction like that is issued, is it a simple majority opinion?
Yes, it takes 5 votes to issue an order. Within the court, they have 4 votes sometimes to grant review of a case. But if you're actually going to do something, an injunction like that is an order to the other courts to stop doing what you're doing and joining the action. It takes 5.
Do you recall the vote on the injunction? Was that a 5-4 vote?
Sure was. And it was, in my view, it was the decision. It decided the matter. The split was clear. And once they decided it, it was over with. I covered, like the rest of the world, what went on Sunday, Monday, and Tuesday. But in my view, it was over about noon on when they handed down the injunction. It was Rehnquist, Scalia, Thomas, and Kennedy and O'Connor. We know that because the 4, John Stevens, Justice Ginsburg, Souter, and Breyer, issued a dissent. And they knew, they were astonished that on that Friday night that Ted Olson that there was actually a possibility that the court would intervene to stop the count. I remember years later they talked about being in plays or something on a holiday parties and being astonished to know that the court was going to meet and that they could possibly, the 5 on the right would jump quickly to shut down the counting in Florida. But that's what happened on Saturday afternoon. all across Florida, there were these county teams going through these punch card ballots. The Supreme Court, on a 5-4 vote, said stop the counting, and we will agree to hear this case on a fast track notice. But as you said earlier, Susan, everybody understood there was a time limit. It had to be done by December 12th. This was Saturday afternoon. Tuesday, the time was going to run out. When the Supreme Court stepped in, stopped the vote, you would only issue an injunction like that if you were the justice, you've got your mind made up. And 5 of them had their mind made up. They were not going to allow that recount to continue.
So for you, just to underscore, that 5-4 injunction vote presaged for you what was going to ultimately happen with the Bush v. Gore outcome in the oral argument.
Yes, I remember telling my editors that afternoon, some news account said, oh, this is a temporary measure to temporary order to keep things on hold until Tuesday. And I said, yes, that's one way to put it. But the truth is, this is the end of this is the main decision. You would not stop the vote counting for the full weekend until early next week, and unless you had decided that the vote count was going to end. I think from Sunday and Monday on, it was only a question of the court's conservatives had to think up a reason for deciding what they had already decided. That is, they knew the decision that this manual recount should come to an end. It's been a month. Governor Bush has had this. We should call this off and end it. Scalia later talked about, this is a national embarrassment or whatever, an embarrassment to the nation that we haven't resolved the presidency. They were very frustrated and that the count had continued. So as I say, they had made the decision. They then heard some arguments on Monday and Tuesday, really to try to come up with a legal-sounding reason for explaining why the count should end. But by Saturday afternoon, the decision had been made.
Well, it's still interesting to listen to the case and some of the questions being asked, even if, as you say, the minds were already made up. So on December 11th, when the case happened, were you in the courtroom?
Mm-hmm. Yes.
And what do you remember from the atmosphere that day?
Well, David Boies was arguing for Gore, and he is a very good advocate, a very terrific trial lawyer before juries, but he had made no headway with the justices. I'm sorry if I'm repeating myself, but I really thought they had sort of, in their minds, had made up. They had made up their minds. Justice Kennedy and Justice O'Connor were sort of fishing around for a reason, and Kennedy had sort of latched onto the idea in his mind was that it was some sort of equal protection violation, because in theory, what if you have a situation where Palm Beach County is saying, we're going to count every vote where there's a sort of a indented punch on the ballot, as long as we can see where it was, if there's a punch next to Bush's name. And then the next county has a very strict standard. It says, we're not going to count it unless the hole has been pushed all the way through. And so Kennedy's view is it would violate the Equal Protection Clause of the Constitution to have these different counting standards in different localities. Now, nobody, I don't think, really made the argument that they had set this up to discriminate against George Bush, that they were going to be easy for Al Gore and hard for George Bush. It was that it's because there was no agreed upon uniform standard that it could differ by county. And Kennedy tried out that view and said, it was clear he was fishing around or trying to get clear in his own mind what was a good reason for saying this recount could end. And that's what I remember, them sort of going back and forth on this. And Ted Olson had a much easier time of basically saying, again, that Governor Bush had won. The Florida Supreme Court is sort of making fools of all of us by continuing this endless recount procedure, trying to find new votes in these punch cards, and it's time for this to end.
We're going to listen to a couple clips several clips from the oral arguments that day, but I wanted to do a small media note as we do this. This particular case was the first time that the Chief Justice granted same-day release of an oral argument before the Supreme Court, a petition that had been made to the court by C-SPAN and then followed by others in the media. So as soon as the hearing was over, the audio was released so that the country and the world could hear what had happened that day. It's a practice that the court has continued throughout since that day in 2000. So let's listen first of all to David Boies and the argument that he made on Bush v. Gore, December 11th, 2000.
In Florida law since 1917, Darby against State, the Florida Supreme Court has held that where a voter's intent can be discerned, even if they don't do what they're told, that's supposed to be counted. And the thing I wanted to say about the Beckstrom case is that was a case that used optical ballots. Voters were told, fill it in with a number 2 pencil. Several thousand didn't. They used everything else, but not a number 2 pencil. And so the machine wouldn't read it. It was voter error. The Supreme Court in 1998, well before this election, said, you've got to count those votes.
Why would the Gore legal team make a change in the attorneys arguing the case?
I don't know for sure, but I think just having listened to both arguments was that, first of all, that Larry Tribe was given a tough time in the first round of arguments. He was, you could tell he was not making a lot of headway with the court's conservatives. And Boies had done the argument in the Florida Supreme Court and had done very well and sort of won. So I assume the people, Al Gore and the people around him said, well, Boies had done so well arguing this case in the Florida Supreme Court, why not have him carry on and make the argument in the U.S. Supreme Court?
Let's listen to Ted Olson making his argument before the court.
Our point is, with respect to the punch card ballots, is that there are different standards for evaluating those ballots from county to county, and it is a documented history in this case that there have been different standards between November 7th and the present with respect to how those punch card ballots are evaluated. Palm Springs is the best example. They started with a clear rule which had been articulated and explained to the voters, by the way, as of 1990. Then they got into the process of evaluating these ballots and changed the standard from moment to moment during the first day, and again, they evolved from the standard that the Chad had to be punched through to the so-called dimpled ballot standard, indentations on the ballot. There was a reason why that was done. Because they weren't producing enough additional votes, so that there's pressure on to change the standards.
Were the arguments that he made this time around essentially the same that he made in the Palm Beach County case?
Yes, and I thought those are very good clips of the sort of competing views. That Boies was quite correct to say that the Florida law said the intent of the voter. And if you had a punch card and it was unclear what the hole had been punched through, and somebody wrote in and with a crayon Bush, you could look at that ballot and say, well, it's clear this voter intended to vote for Governor Bush. And so we should rely on the intent standard is not something new. It's been the Florida law, and it's quite reasonable to take each ballot and say this is a legal vote if we can discern what this voter wanted to do. And that was the sort of liberal pro-recount argument. Ted Olson was making what turned out to be the very good winning argument, which was, look, there are counties all across Florida, and they don't have an agreed upon standard. It's going to differ county to county. It may even differ, he said in this example, where they're actually trying to change the standard he suggested in hopes of finding more votes. And there seems like something unfair about that you're going to sort of manipulate the standard to try to, in effect, manufacture more votes. So I think both of them did a good job of sort of laying out the argument that they wanted the court to accept.
To give our viewers a sense of what it was like on the bench, let's listen to Justice Scalia questioning David Boies.
What the Florida Supreme Court said is that there shall be added to the certification these additional numbers.
But that's true in any contest. Every single contest.
It's not added to the certification.
Yes, of course it is, Your Honor.
You may do a review of the ballots and add more numbers, but as I read the Florida Supreme Court opinion, it said the Secretary of State will certify these additional.
Yes, because the contest procedure is a procedure to contest the certification. What you're doing is you're saying this certification is wrong, change it. That's what every contest proceeding is. And what the Florida Supreme Court was saying after this trial is, yes, you proved that this certification is missing
The certification as rendered by the Secretary of State did not include those additional ballots for your client. And the Supreme Court directed that the certification would be changed to include those.
But Your Honor, that is what happens every time there is a successful contest. The contest is a contest of the certification. You have the certification.
Make any sense to me? You have a certification which is made by the Secretary of State. That is what is contested.
And to give people a flavor of the other side, let's listen to Justice Ruth Bader Ginsburg questioning Ted Olson.
Mr. Olson, you have said the intent of the voter simply won't do. It's too vague, it's too subjective, but at least those words, intent of the voter, come from the legislature. Wouldn't anything added to that wouldn't you be objecting much more fiercely than you are now if something were added to the words that the all-powerful legislature put in the statute?
I think we have to distinguish between whether we're talking about a prospective uniform standard as opposed to something that changes the process in the middle of the counting and evaluating of disputes.
But if we're talking about the contest period, and the statute, as Justice Souter pointed out, speaks with amazing breadth. It says that the circuit judge, this is the text, shall fashion any order he or she deems necessary to prevent or correct any wrong and to provide any relief appropriate under the circumstances. I couldn't imagine a greater conferral of authority by the legislature to the circuit judge.
So what can we take away from both of those exchanges?
Well, that exchange with Ruth Ginsburg reminded me, she was a very smart lawyer, always smart, very well prepared. And she's sort of throwing back to Ted Olson the argument he's making, which he's saying, you're arguing that the Florida courts were changing Florida law. And she said, Florida law says the intent of the voter is what counts, and that Florida law has a very liberal provision for going back and contesting results. And all the Florida courts were doing was abiding by that. Why aren't you asking us to change Florida law, which you said you don't want us to do? So I thought it was a very good sort of counter to the argument that he was making. Justice Scalia, as I mentioned, there was these two parts of the Florida law. First was the certification, and then there was the contesting the result afterwards. I'm not sure. I guess there was some part of the Florida Supreme Court opinion that said these extra ballots have been certified and add those to the total. And Justice Scalia had a lot of doubts, was skeptical of this whole procedure and just sort of adding new votes to the certification, which was, in his view, another example of what's going wrong in the Florida court.
The court issued its opinion at 10 p.m. on the following day, December 12th, and we have the headline of your December 13th story on the outcome of that case. There were two rulings in the case with different sets of votes, and maybe you can help us. We have about 15 minutes left in our conversation. Understand what the significance was. First was a 7-2 per curiam once again, and you told us before that per curiam is the opinion of the court, but this was in fact split. And then there was the final 5-4 decision. So what should we know about those two decisions?
Well, so they, I presume, after the argument, met in a conference and cast their votes, and there were 5 votes to essentially end the recount on the grounds that it was unconstitutional, either that it violated equal protection, which was Kennedy's view, or the Rehnquist-Scalia view was that the Florida court had wrongly changed state law after the election, which violates federal law, because it, as I say, the Constitution says the legislature sets the way of choosing the electors. On the liberal side, both Justice Souter and Justice Breyer had made clear sort of during the argument, they were looking for some sort of middle position. And they were willing to say and willing to go along with Kennedy's view is, okay, if your problem is that the Florida courts have not set a very precise, clear standard that says you've got to punch a card all the way through, have a hole for it to count as say something more specific about what's a legal vote. They were willing to go along with an opinion that would say, okay, we'll send this back to Florida with the requirement that they're going to set a more specific standard and then finish the count. But it turned out Kennedy and O'Connor were not in favor of sending it back and finishing the count. They were interested in ending the count and shutting it down. And so I always viewed that really as a 5-4 opinion. There was a 5-4 split on Saturday. They went back and considered it on Tuesday. They ended up with a per curiam where it's sort of an unsigned opinion. It's an opinion for the court. And then 4 dissents. John Stevens, Justice Ginsburg, Justice Breyer, and Justice Souter each wrote dissents saying, and Souter said, we should never have taken this case. We should never have intervened. We should not have shut down the count. And now we've ended and wrongly ended the case. And Justice Breyer basically said the same thing. I was willing to go along with something that would allow recount to continue, but there's no justification for ending this and shutting it down. So, as I say, it was in my opinion, it was basically a 5-4 split on Saturday and a 5-4 split on Tuesday night. The majority, in not speaking for everybody, understands Justice Kennedy drafted most of that, and it made his equal protection argument that you can't have a recount statewide with all these different counting teams and no clear standard as to what counts as a specific agreement on what counts as a valid vote, and therefore it's unconstitutional and time is up on December 12th, therefore it's over.
And Al Gore came to that conclusion as well. Let's listen to his statement on December 13th, 2000.
Let there be no doubt, while I strongly disagree with the court's decision, I accept it. I accept the finality of this outcome, which will be ratified next Monday in the Electoral College. And tonight, for the sake of our unity as a people and the strength of our democracy, I offer my concession. This is America. Just as we fight hard when the stakes are high, we close ranks and come together when the contest is done. And while there will be time enough to debate our continuing differences, now is the time to recognize that that which unites us is greater than that which divides us. While we yet hold and do not yield our opposing beliefs, there is a higher duty than the one we owe to political party. This is America, and we put country before party. We will stand together behind our new president.
David Savage, in my reading about this case, I took away the understanding that the court meant this to be a singular decision of a circumstance at that time. But in fact, has it created precedent, and has Bush v. Gore been cited in ensuing election-related cases with any frequency?
Well, so I think you're correct on your first thought that the court, they've said this in the opinion that this is basically we're deciding this issue, but Kennedy didn't want to get in. They didn't want to say that there's this equal protection standard that applies to all elections, because everybody in every Hayes could make that argument. Jesse Jackson used to always say, hey, the vote systems in the African American precincts are not as good as in the majority white. They miss more votes. Therefore, that's unfair. The court didn't want to entertain those types of claims. So they basically said, we're deciding this case, and this is not a precedent that should be cited widely. However, it is true in recent years, a lot of lawyers in election cases have increasingly cited Bush versus Gore under the proposition, actually both propositions, that sometimes they say, hey, the legislature in this state and the courts in this state are not following the rules set by the legislature. This has come up during this pandemic. Suppose the state law says ballots have to be, you can mail your ballot in, but it has to be in on election day. And some judges, some courts, some state courts have said, well, because of the mail problems and because of the rush of late mail ballots, this was particularly in the primaries in the spring, some of those ballots may arrive a few days late, but as long as they're postmarked on election day, they will count. People on the other side said, hey, wait a minute, you're changing the law set by the legislature. See Bush versus Gore, you can't do that. And there's also some times when there's been an argument that something is different in one county than another, or if a particular county, suppose the biggest city in the state has a particular rule for how they do something, and some of the smaller counties do something else. Some of the Republican lawyers have said, hey, wait a minute, you can't do that. That's an unequal rule for vote counting, and therefore it violates Bush versus Gore. So it is true that Bush versus Gore has shown up in recent months in a lot of the argument and a lot of discussion. Brett Kavanaugh quoted it recently in one of the decisions, but it's not been, the Supreme Court has not cited it as the basis for a ruling. So it's not quite got to that level of where Bush versus Gore is going to be a precedent that actually the Supreme Court relies on for its own decisions.
Well, let's pivot to 2020, because here we are 2 days after the 2020 election, and once again we have two candidates in very close races. Neither has achieved, of the time we're taping, the requisite 270 electoral votes. And on election night, the sitting president, Donald Trump, announced at 2 o'clock in the morning, really, it was the next morning after the election, that he would ask the Supreme Court to intervene. Let's listen to what he had to say.
This is a fraud on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. So our goal now is to ensure the integrity for the good of this nation. This is a very big moment. This is a major fraud in our nation. We want the law to be used in a proper manner. So we'll be going to the U.S. Supreme Court. We want all voting to stop. We don't want them to find any ballots at 4 o'clock in the morning and add them to the list. Okay? It's a very sad moment. To me, this is a very sad moment, and we will win this. And as far as I'm concerned, we already have won it.
You've just filed a story about the comparisons between Bush v. Gore in 2000 and 2020. You quoted a David Strauss, University of Chicago law professor, as saying President Trump didn't help his cause by suggesting the Supreme Court was ready to ride to his rescue. The justices are all aware that Bush v. Gore ruling did damage to the court's legitimacy. Can you tell us what that means?
Well, I think they all know that the court has a certain legitimacy and respect that as the arbiters of the Constitution, and they care very much about preserving the reputation of the court. A lot of them will say that one of the things that they most think about throughout their career is that they don't want to do anything that would damage the court. They want to leave the court in as good a place as it was when they arrived. And they know that partisan election cases are some of the most treacherous territory, because you're almost sure to irritate 50% of the people that think you were partisan and wrong. And they all know that the Bush versus Gore opinion was very controversial and much disputed. Justice Scalia would always say, "Oh, get over it," and he thought that he'd handled it correctly. But they all knew it was very controversial, and they didn't want to be in the position of being seen as partisan actors, and so they're not anxious to go into that again. And President Trump is very willing to invoke the Supreme Court and say, "I'm going to the Supreme Court." It's a little unclear to me, even when he said that, what he meant by that. He said something about stop the voting. Voting was already over, and they were counting ballots in the state. The Supreme Court's not going to jump in and say stop counting the mail ballots. And Trump's lawyers didn't even ask the court for something like that. So it was a peculiar invocation of saying, "I'm going to the Supreme Court." Who knows what will happen weeks from now? But I don't think the Supreme Court is anxious and ready to jump in and at the first opportunity and decide some aspect of this election.
So your instincts in the middle of December back in 2000, even though people were saying they wouldn't, was that the court ultimately would get involved. Your professional instincts at this point are that the court is very hesitant to get involved. Is that correct?
Yes, it is. I think it's very unlikely they will get involved. It's possible some issue will arise that would cause, that the state courts would decide, and the Supreme Court would get a petition from Trump's lawyers, and they'd say, "Wait a minute, this is clearly not state law, and it's clearly unfair." But I don't see that case at the moment. I've tried to watch the litigation, and there is a pending case that's come up from Pennsylvania, but it only involves the ballots that arrived after November 3rd. And in Pennsylvania, they've been counting, I don't know, some extraordinary number, 1 million plus ballots, but those were already in. And so the issue that the Trump team is raising really involves a small number of ballots that are not even part of the current count. So, I mean, if Pennsylvania would come down to, let's say, Biden ended up prevailing by 5,000 votes, and it included those late ballots, then yes, I can see the Trump campaign would be able to go back to the Supreme Court and said, "See, we believed all along these late arriving ballots should not have been counted because the state legislature didn't want them to be counted, and therefore you should intervene." It's possible, but I think that's a very much of a long shot, because I think the result is going to be settled, and those ballots are not going to affect the outcome, and there's therefore no reason for the Supreme Court to get involved.
So we have about a minute left. With the benefit of 20 years hindsight, how should we look back at the case of Bush v. Gore in 2000?
Well, it was sort of a once of a generation case where, as I say, from the beginning, there were 5 members of the court, 5 Republicans, who sort of took the view of the Bush team, which was, all the votes have been counted in Florida, and Governor Bush has won. I said in this story that I just followed, I thought that's the position President Trump is in sort of now, the position that Al Gore would. It says, once you have lost, once the votes have been cast and counted, and you lost, it's very hard to go to court and persuade a court to essentially step in, jump in, change the rules, and overturn that result. And it turns out that the Supreme Court wasn't willing to allow that to continue in 2000. And it'd be interesting to see if it happens again. But I think it's the kind of precedent that it was an important, obviously decisive case at that time. I don't think the court is anxious to quickly repeat that experience.
David Savage, few people in our country have more experience with observing the Supreme Court than you, from your perch at the Los Angeles Times, doing this job since 1986. Thank you so much for sharing your memories and your analysis of Bush v. Gore 20 years ago. Appreciate your time.
Well, it's great to go through it, Susan. Thank you very much.
Thanks for listening to C-SPAN's Q&A. Subscribe wherever you get your podcasts, and you'll never miss an episode. And while you're there, please take a minute to rate and review us. You can also send us an email at podcasts@c-span.org with your questions, comments, or ideas. Your feedback is welcome.